Well, good afternoon, everyone, and welcome to the first ABLA webcast of the year. It's my great pleasure to be here with you this afternoon. My name's Kate Thomson. I'm a Senior Associate in the Workplace team at ABLA, and with me today I am joined by
Julian Arndt, a employee at ABLA's new Sydney office.
Which I've just been to and is very fancy indeed, so if you ever get the chance, do drop in.
Exactly.
So what are we talking about today, Jules?
Well, we've set ourselves a challenge, or we thought it would be a challenge.
We have
23 key tasks for HR in the year 2023. They said it couldn't be done. They said there's no way you'll find 23 key tasks. How did we do?
We've done quite well, I think, Jules. In fact, we had trouble limiting ourselves to just 23, which with the amount of rubbish you and I can talk, I'm sure no one will be surprised. So
it's a great time to be alive as an employment industrial lawyer.
It is.
All jokes aside, it actually is a great time to be an HR practitioner in the current state of flux, state of change. Lots of new stuff coming your way. A lot of it is landing this year. We're going to take you through 23 things that you need to get on top of this year to make sure the boat stays afloat.
And I think we may have overwhelmed people with the prospect of 23 things to get done.
We'll keep it high energy. It'll be good.
Let's start with our agenda. So I think you'll see some of these terms and concepts are familiar to you if you've been looking at the legislative change that have come about, the legislative changes that have come about in the last half of last year. But not all of them come from the new bill or the Act as it is now.
They don't, and two significant exceptions that kind of slipped in alongside all the bells and whistles of multi-employer bargaining and the better jobs, secure pay, secure jobs, better pay.
The bill.
The bill. If anyone is on LinkedIn, if anyone has followed any of media about industrial relations, you will know that lots has been happening. We're going to hit 8 points today. We're going to start with fixed term contracts, getting into flexible work, parental leave request changes. We're going to talk about prohibitions on pay secrecy. We're going to talk a little bit about bargaining.
We're going to go fairly light on the bargaining though, because I feel like bargaining has been one of the focus areas of the last sort of 3 to 6 months. And you probably, you've heard about that. You know if it's going to affect you or not. And some of these other things I think are equally as concerning or, equally should be high up the list of priorities.
Absolutely on the to-do list. What's the second tranche that we're going to talk about?
So then we'll move into family and domestic violence. So as you said, things that kind of slipped through that might have escaped your notice in the last half of last year. Some sexual harassment, respect at work changes as well. Very, very important. Psychosocial hazards, which is my particular favourite topic of all of these, which is probably concerning to some people, but let's move on. And then we'll talk about the perennial favourites as well. So that's the list of things which you probably should look into and look after every January, every July, and we just want to flag some of those as well as things which might have fallen off the list of priorities in that very busy Christmas period.
It's going to be high energy. If you do have any questions, please pump them through the
system.
Let's start though.
Let's.
Fixed term contracts. So assumed knowledge. One part of the legislative reform, one part of the Labor Party platform is this reticence, putting down negativity about fixed term contracting. What has been introduced in the new legislation has been popularly called now the 2-year rule, which basically means you can't have a fixed term arrangement subject to some really important exceptions beyond 2 years.
Okay.
In the same way, you can't have a contract that has these perpetual rights of renewal that you're allowed to renew once and that's it. I must say, just to editorialise right at the get-go, I actually think fixed-term contracting is not perhaps the evil or the vice that it's been made out to be. I think there is a lot of fixed-term contracts out there. I think a lot of the time they're used for legitimate reasons, and I think employers, generally speaking, are getting better at, if something's a true fixed-term engagement, they engage someone on a fixed-term contract. If it's not, they work out another way to do it.
They can be quite tricky to administer. So I think there's always been some significant drawbacks.
Exactly. It's been a sort of a hot topic for a while now. So you may have already done the first task.
Well, I was just about to ask you what the tasks are. So talk us through them.
Task 1 is audit all fixed-term contracts engagements that you have. Now, I have many clients who have no fixed termers at all. Task done. Brilliant. For many clients who do have fixed-term engagements, the question to ask is, do we really need to structure our business or organisation in this way? And if you don't, then really consider transitioning to something else, because the fixed-term magic bullet will not be available for much longer. If you get to task 2, you've gone through task 1 and you still need or want to use fixed-term contracts,
what do I do?
Well, you need to work out whether you're exempt, basically.
Right.
Kate, there are some exemptions.
There are. My particular favourite, which I think in a lot of instances, we think about fixed-term contracts as something which we might give to our CFO or our CEO. So one of the exemptions that you might wish to think about is the high income threshold exemption. So if someone is over the high income threshold, happy days. The 2-year rule, not a concern.
The marquee player for your favourite NRL team can sign a 10-year contract. It is totally fine. They're being paid enough. But there's other exemptions which are probably closer to home. Exemptions around specified tasks where really something does need to be on a fixed term arrangement. The most important exemption, and probably the most contentious one,
the trickiest one,
is an exemption for a role which is subject to funding, government funding, and that has no reasonable prospects of that funding being renewed.
That's a pretty high bar, Jules.
It's a really high bar. It's a much smaller window than employer groups kind of lobbied for in the process of creating the bill. My message for people looking at task 2 and saying, well, I don't know whether we'll get funding next year, so I can't give out permanent contracts, I have to keep on fixed term. You need to get some advice to ensure that you're going to get through the window, the safety porthole through the exemption, because you may well be subject to the 2-year or non-renewing rule that's been brought in.
So I can see on the top of the slide there, we've got a blue date. Tell me what the importance of the blue date is.
So the blue date is when this starts to apply.
Yep.
Interestingly enough, and you can see there in the latter words of task 2, get a new one signed. I mean, if you did sign a new fixed term contract now, it technically would not be subject to the same limitations in terms of the 2-year rule. However, when that contract that you've signed now runs out, it would be relevant to assessing whether the 2 years of fixed term employment had passed, or whether there was a renewal date and so forth. So there's a strategic question to answer if you use fixed term contracts. There's also a really technical legal one to say, do we have an exemption to continue to use these? If you don't, and particularly if your whole business model is based on, well, we just rely on fixed term contracts and that's how we'll manage our workforce, you need to get some advice.
Great, let's move on. So flexible work and parental leave requests. So I'm sure everyone out there is quite familiar with the idea that since the inception of the Fair Work Act, we have had this idea in the NES of the entitlement of certain employees, not everyone, certain employees to make a flexible work request. So what are some examples of the categories?
So under Section 65, if you have school-aged kids, if you've got a disability, if you are an older Australian, older than 55, I believe it is, and various other categories, some newer ones as well. Now, if you're pregnant, you can ask for flexible work request, which is wild.
We didn't have that
wasn't
before.
Already a part of the criteria.
Agreed.
Also, if you're subject to family domestic violence or you're giving care to someone who is, you have the ability, a legislative ability under Section 65 to request flexible work requests. So maybe working slightly earlier and leaving slightly earlier, or maybe working from home at a particular time. The working from home thing wasn't really a thing until around sort of 2020, when we had this
thing that happened.
We had this incident which meant that a lot of people went and started to work from home. Before Section 65 wasn't really used for that. I imagine it is now, and it will continue to be for reasons which we're about to discuss.
Yes. So you can see there on the slide, Jules, under really all 3 of those tasks, we're really focusing on the process.
Yes, and the reason why we need a process is because in the old world, and pre-7 June 2023, employers made the choice to either accept a flexible work request or to deny it. They had to give an answer, but the acceptance or the denial, most importantly, was based on reasonable business grounds. And they could say, no, we have reasonable business grounds. You can't work from home on that day, or you can't leave early, or you can't, you can't have that particular arrangement in terms of your work.
And the real kicker in the pants for that one, if you were an employee who had your request refused, was you had nowhere to go if the employer's answer wasn't to your liking. And now, the brave new world, as you say, there will be a right of review to the Fair Work Commission. So there's a couple of really important procedural things I'll talk about before we get to that right of review, because I think that's what everyone's focus has been. So in that process, in that period of time after you receive the request, you're going to need to consider the request, as we've always done, and make a decision about whether or not you can accommodate the request. If you can, great, happy days, respond in writing, let the employee know that you can accommodate. These are the terms and conditions. And I think I should add there as well, we've had a couple of clients ask us lately, well, what do we do if we'd like to impose a trial period or a time limit on, let's see if this flexible work request works for everyone. And I think that's a really important thing to think about at that early stage when you are sort of setting the terms and conditions of that new engagement, because the risk that we might fall into is that if we say yes without any limitation, we might end up in a situation where down the track the arrangement doesn't suit the employer, and the employee has an argument to say that that's become an implied term or even an express term of their contract of employment or their terms and conditions of engagement.
Absolutely. And I think keeping in our minds the fact that all of this is through the prism of what will the Fair Work Commission think, given now that the Fair Work Commission can look and impose certain outcomes on employers. I think a trial period seems quite reasonable. I think if you were down at the Fair Work Commission and said, look, we've given it a trial and it didn't work for these reasons and here's the evidence, it's quite you probably will be able to establish reasonable business grounds, as opposed to a much more closed way of thinking, which is to say, it's not how we operate here. That's not what we do.
Doesn't suit us.
Computer says no. It's not going to fly anymore. And yes, I mean, this is what we need. We need a process.
That's right. So what do I do if I'm going to say no? And I think the first answer to that is, well, we need to think really carefully about saying no as a straight out no. The first thing we're going to need to do, though, is meet with the employee to discuss the fact that we're likely to say no or that we intend to say no. The other really important thing at this point in time, if we are going to refuse, is we now have an obligation to suggest other things which we could accommodate. So, for example, Jules, you were talking before about perhaps an early start and an early finish. Maybe we can do that a couple of days per week, but we can't do it as a standard thing on each 5 days of that person's working week. That's the kind of thing that we need to be suggesting as a bit of a halfway house before we just come out and say a flat no to the request in its entirety.
In terms of these concrete tasks 3 to 5, Kate, I mean, the process system, you've very ably taken us through the statutory requirements of providing, what we need to provide and when we need to provide it. The thing that really stands out for me in terms of task 3 is because this wasn't a reviewable right before, it was really ad hoc.
Absolutely.
Like all of these requests would have come from an employee directly to a manager, and the manager would have exercised his or her judgment to say yay or nay, probably in their own idiosyncratic way. In fact, many people did not make Section 65 requests because it wasn't reviewable. There was no point. You just sort of informally ask and it would be dealt with. Now, there really needs to be some consistency about how you deal with these requests.
Absolutely. And
to task 4, I mean, managers need to know that the question of can I work flexibly, can I work from home these days, can I work in this way, it's a new question. It's got a new character because much like an unfair dismissal, it is a decision which the Fair Work Commission could be reviewing, and you need to make that decision on the best evidence after a proper analysis, reasonable consideration, You need a process, and you need to train your people in that process.
That's right. So assuming we do get to the point where we still need to say no, the last couple of things we need to be conscious of are that we communicate that in writing and that we do that within 21 days. And then, as you said, Jules, you can have a situation where the employee perhaps, or even the employer can go off to the commission if there's an outcome which isn't satisfactory to both parties. In the first instance, as they love to do, the commission will conciliate or mediate that request, so they'll try and come to some common ground between the parties. But here's the really fascinating thing now, and this is something we'll talk about when we talk about bargaining in a moment as well. The commission can come in and impose an outcome on the parties that perhaps neither of them wanted by way of an arbitrated outcome if mediation or conciliation is ultimately unsuccessful.
It's really unusual, particularly for all the hardcore lawyers on the line, because normally the legal system works where the applicant makes a claim for certain orders and they either say yes or they say no. Because we're in commission land, it's about solving problems. The commission, in a really quite minute detail, can say, no, this person wants to work this many hours from home, or this person wants to arrange their affairs in this way. This is the outcome in which would be a fair end for the parties. The reason why in the old days, or currently until the 7th of June 2023, these kinds of decisions weren't reviewable was based on the idea of managerial prerogative.
Oh, that old chestnut.
That old chestnut, where basically it was for the business to decide how the business was to run. This is a tweak to that, a stretch of that.
So just before we move on, Jules, talk us through task 5. So standard organisational position. I'm not sure I'm in support of a standard organisational position.
Yeah, it depends. And it's a bit conceptual, task 5, and it has Julian Arndt's name all over it. The reason why I put task 5 in the slide pack is as soon as Section 65 flexible work requests become reviewable by the Fair Work Commission, it does change the game. It does mean that employers need to take much more seriously the idea of flexibility for their employees, particularly those falling into the categories of Section 65. So there is an opportunity, and if there is an opportunity to think about how you work, how you flexibly work, think about what opportunities there are for your employees to manage their work affairs around their various criteria or lifestyles or whatever it is.
Competing life demands.
Exactly. If you aren't asking that question now, you never will. So I say uniform approach be helpful or a hindrance. You need to have a question, because not everyone can make a Section 65 request. But there is a real question. Well, if this person can work from home, could everyone work from home? Now, maybe they couldn't, but at least ask yourself the question. What we haven't mentioned, Kate, is it's not just flexible work requests. It's also parental leave extension requests.
Very good point before we move on, Jules.
Yeah, and this is probably gets to the cynical part of the presentation. Because it is a Fair Work Commission review, potentially litigious process, employers need to be prepared for the fact that Section 65 litigation or parental leave request refusals may well be the sort of prelude case that you run before running an unfair dismissal or running some other claim.
Sure.
A bit like in the old world, someone might bring a bullying claim just before they were terminated. If someone is genuinely upset that their needs weren't accommodated, or they genuinely can't deal with the requirements of the employer, it's likely they'll bring a flexible work parental leave request claim. And then if that doesn't go anywhere, probably the next claim after that.
That's right. So we'll just step back just for a second before we move on, which is to cover off on that parental leave request point. So again, I think everyone on the line should be very familiar with the fact that, provided your employees are eligible employees, they have a right to take 12 months of unpaid parental leave. Of course, that might be conditioned by your policies internally, which might provide for perhaps a period of paid leave, and how that all interacts will be a matter for the business. But there has always, again, been a right to request a further 12 months for an employee, but that wasn't by any stretch a given. 2 years out of the workplace is quite a significant period of time. Again, there wasn't a period where there wasn't a capacity to review those decisions. Now there will be. So again, what we need to be thinking about is, have we got a genuine and defensible basis? If we are going to say no to these flexible work requests, parental leave extension requests, are you happy to stand up in front of a commission member and tell them why you said no?
Well put. Getting a lot of feedback on the chat saying you're only up to task 5. There's no way you're going to get through 23. So let's get a move on. Pay secrecy.
Ye of little faith.
Yeah, exactly. Siren scary, fines may apply if not complete by 7 June 2023. We've got people's attention, Kate.
We have.
What do we tell them now that we've got that attention?
Basically, if you have pay secrecy clauses in your employment contracts, equally in your enterprise agreements, but I'll deal with that in a second, we need to get rid of them.
So pay secrecy or pay confidentiality,
correct,
as maybe the polite way of saying it, is a clause in a contract or an EA saying you cannot tell anyone your pay, you cannot tell anyone your terms and conditions of your employment. They are confidential. There are various reasons which I won't go into, which made employers thinking that was a good idea to put them in. They're actually not everywhere. They're really common though. And again, the policy position from the Labor Party is that pay secrecy clauses, pay confidentiality clauses are, at least in part, a cause of wage inequity, including most famously the gender pay gap.
So if we can't talk about it, no one knows what other people are getting paid, and if you don't ask, then you might be disadvantaging yourself because you don't have that background information.
Precisely, so you can't have them anymore, so you should delete them.
Yep. So what's the scary part about that though? So the position now is that they're unlawful, but what's the kicker in the dead horse there?
The dead horse. The scary part is if you have put a pay secrecy clause in your contract since December last year, but on the 7th of June 2023, you will line up in the sights of the regulator and you potentially could be fined because you would have breached the law by that point, which means if you have issued a pay secrecy clause to someone since December, you have enough time to fix it, but you only have till the 7th of June. If you've entered into a contract years and years ago, you don't need to renegotiate those contracts, but be aware that if you do vary that contract, maybe you give someone a tiny little bump on the 1st of July 2023, the original pay secrecy clause will have no effect.
Yeah.
I think the key thing that you really need to check are your template contracts that you're issuing to people.
What are we using moving forward?
They should not have pay secrecy clauses in them. If you've if you've unfortunately sent one out in the last 2 months, you can still fix it, but you need to get on your bike and fix it soon.
So there's task 7 and task 8 there. I think they're really interesting cultural questions that we should talk about before we move on as well. And I think some of the feedback that I've been getting from clients is, well, we review the contracts, that's fine, we can do all of that. But how do we actually deal with people talking about their remuneration in the workplace?
I love task 7 because unlike task 6, and to be honest, unlike our last discussions of basically fear of the commission becoming involved, task 7 is something proactive. It is being open-minded to the fact that maybe we are the problem. Maybe our pay structures aren't actually right, and maybe maybe it's okay if we live in a world without pay secrecy. Review your pay structures and your data. If there are reasons why people are paid at different amounts, I'm sure there are. Brilliant. If it's obvious that your pay structures are wrong or that someone is being well underpaid compared to someone else, you should fix it. Why? Because it's much more likely to become a problem now because you can't require people to keep their pay confidential anymore.
That's right. And I think it's really important to note at that juncture too that the right to ask those questions and the right to disclose that information has now been inserted into the general protections provisions of the Act as well. So people asking those questions, just as they always have had the capacity to ask you as their employer questions about their pay and expect to be able to have those questions answered without fear or favour, that those are our workplace rights in the same way now. So it's really important to understand that this might happen and there isn't much we can do about it from a legal perspective. So let's approach it from a cultural perspective.
Yeah, and let's have a good answer, right? So what isn't a good answer is, well, that's actually confidential. It's actually confidential because it's actually not. And they may have spoken to the other employee and they may have got the details and they may have more information than the manager does. Task 8, you need to develop a strategy to deal with questions about pay and rumour. I just made that phrase up. I don't know, maybe it'll catch on. Train your frontline managers to be able to respond to these questions. There are broadly two schools of thought on how to respond to a question saying I'm being underpaid compared to Harry, who does my job. There is the path of least harm, which is to say, look, it's very, it's very complicated and just trying to get through without saying anything. Or you can have a direct conversation to say Harry is better at his job than you are, and that's why you get paid less. That second option is quite high risk. You need to think about how you're going to deal with these things. And ideally, hopefully, you don't have to have that conversation because you set your pay right and you can kind of...
There is a defensible position there. And just before we move on as well, I think it's really important to note that employees can ask their colleagues questions. Those colleagues don't have to answer.
Yeah, true. Well, and also, I mean, they might answer dishonestly.
That's right. Exactly why we need a strategy to deal with these sorts of discussions.
This is the other really interesting part about responding to employee complaints is that they may have bad data. I actually like, and I've given this advice to a few people, that instead of directly engaging with like the sort of the attack of you're underpaying X, Y, and Z, you can just say, look, I don't think you have all the facts, particularly if they do not have all the facts. That has a way of kind of working it out. But look, I'm interested to see how this goes. Is there a prospect that there might be, interesting hostile work environments being created when people are forced to tell people their pay? And it's a very un-Australian thing to do. People do not like discussing their pay.
No, but, that doesn't mean that in this brave new world, we're not going to see those conversations happen. And I think we just need to, like with most of the things we're going to talk about today, let's think about them. Let's be proactive rather than be reactive, which unfortunately a lot of us in HRIR have had to be over the last 3 years.
Yeah. Let's kick on to bargaining. As you said, bargaining was the big boogeyman of the legislative change.
Yep.
It got all of the volume. It got a lot of controversy. Will they, won't they pass it? They have passed it, but none of it's sort of landed yet for the most part. It will land in 2023, and we'll probably...
On the 7th of June,
yeah, we'll have a lot to talk about when it does, and things will become much more clear. There are some real key points we want to hit and maybe some questions we want to ask. Task 9, the hand rising from the grave.
Zombie kill list. I have to say, when I got the email from the Commission, and if you don't get the Commission's update emails, I encourage you to sign up to them, and it actually referred to the zombie list the other day. I was quite excited about the fact that nomenclature had caught on. So what are we talking about there? Well, hopefully if you have a zombie agreement, you know that you have a zombie agreement. They are pre-reform, pre-Fair Work Act agreements. So at the end of the previous government's workplace relations era, a lot of people rushed in to try and negotiate an enterprise agreement under the previous legislative regime before the Fair Work Act became the relevant piece of legislation. People had 5-year agreements under that legislation. And of course, the benefit to a lot of employers was that they applied a different test to those that were approved under the Fair Work Act against different industrial instruments as well.
Or bargaining was relevant 2010 or before, and then everyone's forgot about it. And no one's been interested in bargaining for the preceding 13 years, and they've just sat there. And then all of a sudden, ding dong, Fair Work Commission sent you an email saying, actually, you're on the
zombie kill list. So what does that mean? Basically, it means that we had always anticipated I think had always been the intention that those agreements would at some point drop dead.
They're out of date.
They're out of date.
They are completely out of date. They're entirely legal. Let's make that very clear.
That's right.
Being on the zombie kill list, despite what certain media outlets might have you believe, there's nothing unlawful about it. There's no shame in being on it. They just got a really old agreement that no one's bothered to change or vary or replace. However, the time is short. By the 7th of June, you have to inform people about the fact that is it the 7th of December?
That's right, yep.
The zombie will be laid to rest. It will be, I don't know how to kill zombies. How do you kill zombies?
I don't watch those TV shows, so we'll need to upskill by the 7th of December.
Brilliant. So they die on the 7th, and you either fall back to the award. probably, I mean, a lot of people might find themselves bargaining in the new world of bargaining after not being in bargaining for many, many years. Maybe you'll get a replacement agreement at that point, but we will wait and see.
Well, that's a nice segue into task 10, which I believe is alluding to the fact that the Commission, as I mentioned before, is going to have a whole range of more interventionist powers when it comes to dealing with or helping parties to resolve disputes when we're involved in bargaining.
The new world is a world where the Commission arbitrates. They make decisions about competing sides of bargaining. The old world was about you leave parties to themselves. They talk. If things go really bad, that someone starts striking or the employer starts locking out, and then eventually their heads come together and you have an agreement. The new world gets much more quickly to Commission, here's our case, this is what we want in our agreement. Other side says their case and the Fair Work Commission imposes a result. If you just get this weird feeling that you've been bargaining recently and just for some reason just things aren't moving the way that you think that they should have been, there's a likelihood, there's a prospect that the reason things have slowed down is because the employees, the union, are waiting for changes to occur. And it's not actually just the Fair Work Commission's new role in arbitration. It also is the hot topic, the radioactive topic in the passing of the bill, which is multi-employer single interest bargaining, or messy bargaining, another phrase that I'm looking to popularise, where you get multiple employees to all bargain together.
Yeah.
We're a long way from that.
We are.
In terms of I'm not telling you need to be running out and sort of becoming the expert on multi-employer single interest bargaining. But if I was bargaining and things are kind of slowing down, I would start to be thinking strategically about what might be in the future and whether you need to get something signed, sealed and delivered relatively soon.
So just to be very technical for a second before we move to 11, so two things I think we need to think about there are, as Julian said, we're thinking about the Commission's power to come in and impose an outcome. That's a concept, or that will be in response to an intractable bargaining dispute, which isn't quite as sexy as some of the things that you're trying to introduce as, commonly accepted terms, Jules. But look, it's in the legislation. They were limited in what they could do. So there will be a process, there will be a conciliation process that you have to go through there. So again, the Commission or the legislature has tried to say to people, look, we're going to give you the opportunity to sort it out with the assistance of the Commission, so like our flexible work requests. And then if you really can't sort yourselves out, we're going to come in and be the final arbiter of those terms and conditions that you guys can't agree on, which again might not even be things which suit either side particularly well. The second thing that I'll just note there before we move on is something I find quite interesting, which is, again, inserting this idea of compulsory conciliation or mediation into protected action ballot order applications. So if you've had the unfortunate situation where you're bargaining, the employees or the unions have decided they don't like where things are going, they're looking to take some industrial action. Traditionally, throughout the life of the Fair Work Act, basically all they've had to go do is go up to the Commission and say, look, we're trying, we're bargaining in good faith, we can't reach an agreement. And the Commission would issue an order for the employees to be balloted. As a bit of a safeguard, I think, to try and make sure that we're not rushing too hastily down the path of industrial action, particularly with some of the multi-enterprise agreement processes, messy processes, you will have to have some conciliation at that point before they'll issue that order as well. So just another step in that process, which might sort some things out. It might be a colossal waste of time, but we'll have to wait and see. That's cynical of me, isn't it?
Yeah, I also am, thinking about the fact that we said we would only gloss over bargaining, but you just could not help yourself, Kate. You had to get into the technical terms and the nitty-gritty of it all. If I could make it simple, the point of these changes is to get more enterprise agreements, get more employees covered by enterprise agreements. That's
the fundamental.
To raise wages.
Yep.
That's the point.
Yeah. So task 11, and I think this is, you've alluded to your messy agreements.
This is the point, right? Is that if anyone is going to end up on an EA who isn't currently on an EA, bearing in mind the point of this legislation is to get more people on EAs, it's a firm, an organisation who currently doesn't bargain, but kind of have competitors who do.
Yep.
You're going to need to get ready. If you are in a particularly vulnerable industry location union environment, such as high union density, or a lot of these industries which award reliant, but there's been a lot of talk about that. Actually, we really do need to have enterprise bargaining in, for example, childcare centres or in disability care, so on and so forth. You need to get ready. Task 13, it says it all. Develop an industrial strategy. Task 14, acceptance, or should that be surrender? I mean, I don't love that. It's a bit negative for me, negative Nancy for me.
That was my input into the slides, so you're welcome.
The point is that this is the new world. The reality is that many firms, many organisations will be drawn into bargaining. There are opportunities for bargaining. It would be a mistake, I think, to treat this as something that, well, we can dodge, we can avoid, we can hedge, we can kind of, we can try and stop. I don't think you can stop a group of employees or a union who wish to set up an enterprise agreement, and certainly it's a lot harder to stop than it once was.
Absolutely.
Engage in the process, get the right advice.
Be proactive.
Exactly. Also, if employees are happy, with the employer, with what the employer is providing, it's much easier to keep them happy and so that they do not get involved in your parbos, involved in your various strike actions and so forth. So
what's the bottom line here, I think, Jules, is we need to give some serious thought to some of this stuff.
Yeah, because it's coming.
It's coming. Let's just accept that it is and use it as an opportunity to be proactive rather than reactive, as we keep saying.
It's a slow burn, though. The whole world is not going to change on the 7th of June, but we'll have much more to say throughout the year. And sitting in this seat, as I hope and pray that we are, in 1 year's time to open the 2024 webinar series, I think there's going to be some fascinating things that are going to happen in bargaining. Again, we said we didn't talk about bargaining.
No, we've talked about bargaining for far too long.
Family and domestic violence leave is not something that was in the legislative change or the big bill that came through last year. It did have its own bill. It was the first thing the Albanese government actually did. It piggybacked off the Fair Work Commission's decision to introduce 10 days paid leave into all modern awards. It's been extended to everyone. I think most people know this. What people may have forgotten is that it's all starting now. As of February, if you have 15 or more employees, all of your employees now have 10 days paid family and domestic violence leave. If you're a small business, you've got till August. Now, it's a technical question. I mean, it's a payroll question.
Do I need to worry about it now, or am I in the August group?
Yeah, exactly. If it's already commenced, I'm hoping that you've already done something about it. To be honest, I think if you hadn't done something and an employee had made a claim for family and domestic violence leave, you probably would have made some calls and fixed it by now. Some of the questions that we're getting are around pay slips.
Very sensitive.
Yeah, very sensitive. There are prohibitions in the regulations about what goes on pay slips. If your pay slip currently has reference to domestic violence leave balances, or that people made a domestic violence leave application and have taken some domestic violence leave, you need to sort out your payroll immediately, because that is not how you should be operating. Your pay slip should be quite vanilla in terms of this form of leave. But I think from my perspective, Task 16, this is why I've said it's really important. I don't think there's any other form of leave in the Fair Work system that is as difficult to have the direct engagement with the employee. I want to take some annual leave, you make a computer request. You want to take a sick leave, you probably text your boss. Domestic violence leave needs a procedure and an understanding and some training about how to deal with people who are asking for the leave, because it is such a broader issue, and I'm just not going to be at work today. And to be honest, it's very challenging for the HR people or the manager who needs to accept these requests or to make a determination of these requests. Please help them out. Get a procedure for notification so all the employees know, so they know where to go, so you don't add to their stress, but also from the internal side, get a procedure so everyone knows what to do. I'm a big fan of having a central contact point for dealing with it.
I think that's a great idea too.
Really helps for confidentiality reasons. It's not something, and there are obligations on keeping these things confidential. It is not something that you want to have everyone knowing about. It's not something that you want a large group of people knowing about. Once you need it to be confined. Task 17 we've already dealt with. Small business, it's going to be a challenge come August 1. We expect many calls at ABLA and at the chamber. Yeah. So if you do need any help, please call through. The other sort of non-secure jobs, better pay piece of legislation that came through was sexual harassment respected work changes. This is pretty massive.
It's a big deal. So we did have some changes during the life of the coalition government. They did adopt some of the changes which were recommended in the course of the Respect at Work report, but they didn't go and wholeheartedly adopt all of them. And I think that the one that they didn't adopt wholeheartedly, which was the major one that's of greatest significance now, is the positive duty. Positive duty of employers to prevent this type of behaviour or this type of thing happening in the workplace.
So let's unpack that, Kate. Previously, and I think how most people would think about sexual harassment or really any kind of negligence-related thing, you would think, well, so long as we didn't do anything to cause it, we'll be okay.
I think that's a fair, yep.
We need to stop thinking in that way about sexual harassment, and we need to think much more like we think about safety, which is safety is you have when people talk about a duty of care, you have to, so far as reasonably practicable, ensure the safety of all your workers. In the same way that to satisfy the positive duty to prevent sexual harassment, you actually have to do something. You have to be seen to have done something.
Probably a few things.
Precisely. If you do nothing and say, oh, well, no one gets sexually harassed here, we've never had a problem, you actually will be in breach, which is really fundamental because of the nature of the subject. A lot of firms, a lot of people kind of think, well, we don't have a problem.
We don't have that kind of behaviour here.
Exactly. And that might be right, but that's not how the law works.
No.
So what should you be doing?
So that's task 18, which is really just to get your head around the fact that the lay of the land has changed. The expectation of the regulators, of which there are a couple in this space. Again, the Commission's got some additional powers, which, we'll see all of those kinds of applications play out. But before we even get to that stage, we really just need to accept and appreciate we do have this positive duty, which leads us into 19 and 20. So 19, which is create or update, if you already have one, which would be great, a policy which deals with the things and the steps that you're going to take to prevent sexual harassment or sex-based discrimination from occurring, and a training package, because having a policy, Jules, is no good if people don't know about it, if they don't know what their expectations or your expectations of them are, their rights.
Realistically, everyone already had policies. But there is a change. Again, understand that this is a fundamental change, understand that you need to do more. We can help.
We can
on this front, and we will give some details at the end of the presentation about what we can do. But contact us if you are sitting here thinking, I actually didn't really appreciate the fundamental shift that the Respect at Work changes will make. And I know a lot of people out there take safety really, really seriously. Thankfully, this is something to take equally as seriously and to kind of think in the same way.
That's right. And that's where you'll see task 20 on the bottom there. And I'll just put my safety hat on for a second.
It's a great hat.
It is a great hat. You really just need to be looking at sexual harassment, sex-based discrimination, those types of behaviours. And I would probably put bullying in that category as well for the reasons I'll talk about in a moment. Treat them like you do the rest of your work health safety risks and hazards. Put them into your risk management framework in the same way you do, traffic management or PPE or those sorts of things which, we just accept are safety issues. These are not just HR issues anymore. And if you're an HR practitioner thinking, great, I can share some of that responsibility with one of my colleagues, well, you're welcome. But it's true, these things need to be looked at from a more holistic frame of reference than they previously have been, and as just as important as some of those more traditional concerns.
To drill down, I think the risk management, risk assessment point really does make the point about how different all this is. I don't know how many people watching this would have ever thought deeply about doing a risk assessment for sexual harassment in the workplace.
That's my call to arms, Julian.
This is
that
what
my
Kate,
call to arms.
with her work health and safety hat on, is asking you to do. Have you actually, as you would with some loose cords on the table or ergonomics or a thrashing machine or whatever it is, worked out where are the risks for sexual harassment? And there are many. Clearly, there are many. You need to actually go through them, have a framework to avoid them.
That's right. In the same way, and I'll get you to move on.
Of course.
Jules, to psychosocial hazards. Again, one of my particular favourite topics. So psychosocial hazard, you think about things like bullying, but think of things like workplace stress, things which have the capacity to create a hazard really to someone's mental health or their psychological health and well-being. Not in the same way, again, as we're thinking about our traditional safety-related concerns, which are the thrashing machine, the unguarded machinery, the poison or the hazardous substance. These are the things which cause risk to people's psychology or their psychological well-being. So first thing I'd like to ask everyone to do is understand what they are and how they can be prevented. And in that regard, Safe Work Australia have produced some really good resources. There's a new code of practice, which deals with psychosocial hazards, which I think if you haven't had a look at those sorts of materials, I'd really encourage you to do that. The benefit of codes of practice and those sorts of documents is that if you follow the steps set out in those codes of practice, that's one of the ways you can defend yourself if the safety regulator comes knocking and says, well, what have you done to manage these risks in your workplace? And then task 22 there is the same as our sexual harassment call to arms. Add these things to your work health safety risk management framework. So, 2 years ago, Jules, I would have said to you, look, these sorts of things, bullying, harassment, stress, they're obviously important. They're important from a workers' compensation perspective, and they were and have always been important from a safety perspective. But in terms of the list of things which were likely to attract the attention of the safety regulator in your jurisdiction, well, they just weren't really up there, to be honest. In the last sort of 12 to 18 months, there's been a significant increase in funding, a significant increase in scrutiny on these sorts of things and how they are administered in workplaces. And we have had a number of recent instances of regulators coming in and doing investigations in the same way they would ordinarily do for a fatality, a near miss, a significant injury in relation to a psychosocial hazard.
The other thing I might say about that is that the unions are very well versed in this. If this is a bit foreign to you watching, it's probably quite likely the union or an employee will come to you with this type of claim or this type of request for an investigation or something along those lines. You want to have your risk management framework already set up. You want to be proactive about these things because it's, I don't know what you would call it. I mean, it's an emerging trend that, as you say, 2 years ago, it's probably a different conversation. Now, increasingly, it's something that you will have to deal with from a safety perspective, which is really interesting because the world of safety, as we mentioned in relation to sexual harassment, it is a bit different and certainly something that you need expertise in. So, again, if you have any questions about psychosocial hazards, Kate would be very interested in getting
Happy
a call.
to hear from you. Perennial favourites.
So we've got a tiny bit of time, and I don't mind doing these quickly either, just to prove everyone wrong that we can finish on time. This is what you should be doing every year, basically, and it's one task 23, but these are things that are important. They're always things that people fall down on. They're the things that will cause you great deals of stress if you get wrong, and you'll be happy and healthy and free if you get them right.
Talk us through all of them.
Rates of pay. Ensure that you're paying correctly.
So let's unpack that for a second, Jules. So I think, one of the things that we quite often see people do, or a pitfall or a mistake that people quite often make, quite unintentionally, is setting rates of pay at a particular level at a particular point in time, and assuming that that's probably going to give them enough wiggle room as compared to the modern award, for example.
We're over awards, so
we're over awards, so it's fine. And then, 2, 3, 4, 5 years down the track, perhaps that, 10, 20, 30, 40% above award rate that you were previously paying, which you might be relying on to offset some allowances or perhaps even some additional hours, is really not the wiggle room, or it's not providing you with the wiggle room that you thought it was.
It's a really good point, Kate, because it's not just about checking base rates of pay. Really important that you check them in this inflationary environment. The likelihood that award rates of pay are going to go up and up and up is very high. But also, if you're relying on that fat in your pay rate to cover reasonable overtime and the like, it might actually be much closer to the bone than you think. So now is the time to check it, or at least check it this year, as and when you can. Industrial instruments, I mean, hopefully you know whether you're on a modern award. If you know that if you've got an enterprise agreement, you definitely know you're on that, presumably, unless you've forgotten about the zombie agreement. But
which some people have, and that's okay.
That's okay, and it won't matter for too much longer. Just ensure that you keep up to date with what's happening with modern awards, and what if there is any question about whether people are award covered and maybe they're not, reach out for advice. That is a perennial favourite, that question.
That's
so
right.
Happy to help with that.
I think as well, Julian, the other really important thing to note there is if you downloaded a version of the Modern Award, in 2018, 2019, I hate to break it to you, but it probably looks very different now. It's probably even got a different number attached to it.
2020.
The 2020 versions of the awards. So really important just to be keeping up to date with those, the changes. They are quite often happening without even perhaps that much publicity. So, use the resources that the Commission makes available.
Workforce composition, especially independent contractors and casuals. Now, the reason why we've put independent contractors and casuals in there is because I think, pretty sure, there will be some legislative movement on these issues in the coming year.
Yep.
So if you can regularise your engagement of casuals, I mean, the issue was fixed through the introduction of 15A, which defined basically if the contract says you're a casual, you're a casual. It's very unlikely that that's probably going to last
too much longer.
At least the parliamentary term. But independent contractors as well. Again, it's another great old chestnut. Is someone really an employee, or are they an independent contractor? Again, some helpful clarifying High Court law about this, but it's good to get it right. Long-term absent employees, don't leave them. Don't leave them out. Get in touch with them if you have not got a plan with one of your long-term absent employees. You need one. Call us. We can assist with this. It's very important to be proactive in managing these people who are out of the workplace on long-term basis.
I think it's really important there to note, Jules, as well. I think some people have developed an expectation that, particularly if someone's on workers' compensation and it doesn't look like they're going to be able to come back to work, that somehow through the passage of time, something will happen to the employment relationship, and that's just not the case. So if you've got someone in that category, we don't think that they're going to be able to return to their pre-injury role. We need to do something about it. Equally, if we've got someone who's unwell or absent for whatever other reason that's not a workers' compensation injury, we do need to be proactively managing those types of situations.
There's no easy solutions, and there's no quick solutions.
No.
But you do need a solution.
That's right.
You need a strategy. You need a timeline. So I would want, if I was an HR practitioner, I would want a list of all the people who have been long-term absent, and I would want next steps and the steps after and following. Employment contracts, obviously we've talked a bit about pay secrecy, what might need to be an employment contract. You should also check whether, if you have copies of everyone's employment agreement. There's employment contracts can always improve. Every year we kind of come up with, or at least we debate internally about having a tweak to our own template employment contracts as the law changes, as cases get handed down. So again, July 1, if you're going to give someone a little bit of a bump, that's the opportunity to sign them up to a new, fresh, compliant, brilliant employment contract that crystallises all the terms of their employment perfectly. And policy and procedures, well, that's very general, Kate. What do we say about that?
I just think it's a good opportunity to have a think about our policies and procedures. We've suggested a couple today that might need a particular refresh, such as the bullying and harassment policy. But what I see, and I'm sure you see as well, Jules, is, when we start to deal with a difficult employee or a dispute, we'll get copies of policies sent to us which have review dates, which have long since passed. And I get it, absolutely. I understand that everyone out there watching is very busy, and probably reviewing your policies and procedures isn't high on the list of your priorities. But it's really, really important, because when we're managing difficult situations, when we're managing difficult employees, they're really one of the best tools that we have in our arsenal. So let's identify any gaps. Let's update, refresh, make sure that they're sufficiently prescriptive, that it gives you a defined course of action, but at the same time gives you the degree of flexibility you need to be able to be responsive to a particular situation.
And if I was getting 3 policies, I would be really looking closely at a domestic violence leave policy. I would be really looking at a flexible work policy, and I would be really looking at a sexual harassment respected work style policy, because they're the 3 kind of major policy shifts that beg the question, well, is your policy going to be up to date? If you haven't changed them since those big shifts, probably not.
How can we help?
Well, we can give you all those policies.
We can, and we can help you review them if that's just something that seems a little bit too beyond the pale at the moment.
The ones I would probably focus on, because they're actually quite difficult to just click your fingers and produce, is the positive duty sexual harassment suite. Please contact us if you're interested in getting some material which should sort you out on that front. We've also got a similar flexible work product. If you are interested in the whistleblower hotline service, I won't go into whistleblowing, but if you need a whistleblower hotline, you know who you are. We can also help you with that. We do heaps of training. We've got some excellent trainers, including yourself, Kate. We do this a lot. Please reach out to us. We can tailor what you need for your business. So please reach out to us. There's also the next webinar. What was it? The next webinar is?
It's an introduction to bargaining, I believe. It's
Nigel Ward and
Kyle Scott.
So stay tuned for that. Like and subscribe on YouTube. It's been an absolute pleasure, Kate. I had a great time.
Do we have any questions?
Oh, we've got heaps of questions. For those who have asked questions, unfortunately, I've made a decision that a lot of them are incredibly specific and probably not overly conducive to answering in a public forum.
So unfortunately, we're going to have to probably throw them over to another time.
I think that's right. There's a question about proof for domestic violence leave for an employee, medical or police certificate. Yes. Just on that point, we already had unpaid family and domestic violence leave. The evidence requirements are the same. It's evidence that would satisfy a reasonable person that the leave needs to be taken for the purpose that it's asked for. In relation to these other questions, please reach out, and otherwise, it's been a pleasure.
Has been. Thanks for joining us.
Cheers.